Every year, police departments and prosecutors' offices across the United States boost their budgets by hundreds of millions of dollars with property seized on the suspicion of criminal conduct using the process of civil asset forfeiture. Too often, though, the property owner is never convicted. While this practice of policing for profit has been long criticized, we think it is now more urgent than ever to create tools to address the problem. I would like to show you the prototype for a new product my colleague and I have created to assist citizens with challenging civil asset forfeiture in state and federal court. For those unfamiliar with civil asset forfeiture, we've embedded a brief video to introduce the body of law before beginning the interview.
Civil asset forfeiture is a legal process where law enforcement can take your property and keep it, regardless of whether or not you are ever charged with a crime.
Our product addresses the need for a user-friendly resource for drafting answers and affidavits to contest forfeiture proceedings. This is a tool without rival in the legal market, and one that has the potential to begin helping people immediately. Civil forfeiture laws vary by state. For our case study, we have selected Iowa, a state with some of the most police and prosecutor-friendly forfeiture laws in the country. Iowa state law establishes a process for challenging forfeiture by written affidavit. Still, we have identified a line of cases where challenge was unsuccessful simply because the property owner submitted a substandard affidavit. In one case, an Iowa court wrote that the owner's answer failed to comply with the specific requirements in several ways, including by more closely resembling a letter rather than an answer. Our product specifically addresses this issue. Our interview process gathers all the information required to challenge the case, and our product is programmed to process the information into an affidavit that meets the formal requirements of the court. Many civil forfeitures end administratively, meaning that the property is automatically forfeited after a certain period of time because the owner of the property did not challenge the seizure. Meeting filing and response deadlines is critical to successfully challenging civil forfeiture, just as recognizing when the state has allowed the statute of limitations to lapse can be all one needs to win the case. But the window for filing an answer or submitting a petition is often tight. And for citizens with no legal experience or assistance, identifying the deadlines and meeting them could be a considerable challenge. Using conditional formatting in Documate, we have crafted a workflow that calculates due dates from the client's previous answers and displays the final day for submission, as well as a past due warning, an upcoming deadline warning, and a warning that the statute of limitations may have lapsed. Because of the relatively low value of property involved in many forfeiture proceedings, hiring an attorney can be impractical, if not entirely out of the question. We have crafted an online interview process that is accessible to lawyers, law students, and non-lawyers alike. Today I'm demonstrating the workflow for a legal clinic volunteer interviewing a client who has received notice of pending forfeiture. More generally, we have sought to create a structured workflow using page and question logic to mirror how an experienced attorney would approach working through a civil forfeiture case, asking and answering questions about the conduct giving rise to forfeiture, the property subject to forfeiture, and so on. This product is immensely scalable. It can be expanded to fit every jurisdiction, and it is easily updated as the law changes. By the end of the interview, the user can print documents for the petitioner to sign and submit to the applicable court and prosecutor, at which point they will be well on their way to challenging the forfeiture of their property.